It was a showdown today in the mushroom murder trial. The lead barristers of both the prosecution and the defence addressed the jury, with Nanette Rogers finalising the Crown's argument that Erin Patterson told lies upon lies when her murder plot started to unravel.
We say there is no reasonable alternative explanation for what happened to the lunch guests other than the accused deliberately sourced death cap mushrooms and deliberately included them in the meal she served them, with an intention to kill them. In the lead up to the lunch and in the periods after the lunch, Erin Patterson told so many lies it's hard to keep track of them. She has told lies upon lies because she knew the truth would implicate her.
Meanwhile, Colin Mandy started the defence case by saying his client never planned to kill her lunch guests and had a motive to keep them in her world.
She didn't plan it. She never planned to kill anyone, and when they did get very, very sick, she panicked, because that's when she realised that it might have been the meal and the spotlight would be on her, and that's a very powerful reason why you can't, in our submission, find this element of intention. It's why you should have a reasonable doubt about it. It is an implausible theory when you take a step back and look at the big picture.
In Room 4 of the Latrobe Valley Law Courts, both sides came out swinging. I'm Brooke Grebert-Craig, and this is The Mushroom Cook. We just finished day 33 of Erin Patterson's trial, and as always, I'm joined by court reporter Laura Placella.
We've had a big day.
Yes, another one. This morning, Dr. Rogers continued with the prosecution's fourth calculated deception, which was the sustained cover-up Erin embarked on to conceal the truth. To remind listeners, the other three were the fabricated cancer claim Erin used as a reason for the lunch, the lethal doses of poison Erin secreted in the beef Wellingtons, and Erin's attempts to make it seem like she also suffered death cap mushroom poisoning.
So there were 4 elements to the sustained cover-up, 2 of which Dr. Rogers mentioned yesterday. But today she turned to the disposing of the dehydrator that she said Erin had used to dehydrate death caps. Erin has admitted that she dumped the appliance the day after she was released from Monash Medical Centre. But Dr. Rogers said today the only reason that Erin dumped it was because she knew she had used it to prepare the deadly meal. This is what Dr. Rogers said today. These are her words, but not her voice.
If there was nothing incriminating about the dehydrator, why hide it? And there is only one reasonable explanation. She knew it would incriminate her. She knew that she had dehydrated death cap mushrooms in that appliance and that she had deliberately done so. And she knew that keeping it was going to be far too risky. So one of the first things that she did after getting back from the Monash hospital was to race out to the tip and dump it. Try to make it disappear. If not for the careful analysis of the accused's bank records conducted by Senior Constable Meg Crawford, no one would ever have known about the dehydrator. Erin Patterson certainly wasn't telling anyone about it. In fact, when she was asked by police during the record of interview on 5th of August whether she knew anything about a dehydrator in her house, she answered with a completely straight face, no.
Dr. Rogers then moved on to the last element of the sustained cover-up, which was Erin deliberately concealing her usual mobile phone from police. Dr. Rogers talked the jury through phone A, which was her usual phone B, which was her dummy phone, and phone C, which was her Nokia phone. Laura, let's start with phone A.
The game of phones continues. So with phone A, as you just said, Brooke, Erin's usual phone, Dr. Rogers explained today that this phone was using the SIM card ending in 783 in the lead up to the lunch. And she said this SIM card was also in phone A right up until the start of the search warrant, which was executed at Erin's house on August 5. But Dr. Rogers told the jury today that while detectives were at Erin's house, phone A was being handled without their knowledge. She reminded the jury of the evidence that the SIM card lost connection with the network at some point that day between 12:01 p.m. and 1:45 p.m. and she alleged this was because Erin removed the SIM card before concealing phone A from police. She reiterated to the jury today that police have never been able to recover phone A, even after returning to Erin's house for a second time in November.
Let's move on to phone B. What did Dr. Rogers say about that device?
For the first time, we heard Dr. Rogers call phone B the dummy phone. And this was the device that Erin handed to police at the end of the search on August 5. And she accused Erin today of setting up this dummy phone to deliberately trick the police. She said that police found nothing on phone B because it had been factory reset multiple times by Erin, including on August 5 and August 6, the day after the search. She then turned to the SIM card that was in phone B when it was handed over, and that was a SIM card ending in 835. Erin claimed last week that she was setting up a new phone the week of the search. But Dr. Rogers said that the jury could reject her claim because it was not a phone or a phone number that the accused could say she was truthfully using.
Great, let's finish with phone C, which was the Nokia phone.
Dr. Rogers told the jury that after Erin took the SIM card ending in 783, which was her usual SIM card, out of phone A, she then later placed it into phone C, the Nokia. She said that Erin continued to use this number in phone C even after she returned home from her record of interview on August 5. She said Erin's usage of this SIM card made it quite clear that this was her usual SIM card and not the SIM card ending in 835 that was in phone B when Erin handed it over. Here's Dr. Rogers' explanation for why Erin did what she did with the phones.
All of this conduct, the factory resets, the handing over of the blank dummy phone, pretending that phone B was her phone number, all of this was designed to frustrate the police investigation of this matter. It was all done so that the police would never see the contents of the accused's real mobile phone. We suggest to you that the only reasonable explanation for engaging in all of this deceptive conduct is that she knew that the information on phone A, her usual mobile phone, would implicate her in the deliberate poisoning of the lunch guests.
After Dr. Rogers finished her 4 calculated deceptions, she moved on to Erin's claim that she must have accidentally foraged death cap mushrooms.
Dr. Rogers said that she anticipated the defence would argue that the jury cannot discount the possibility that Erin had innocently foraged for wild mushrooms for a family meal, but accidentally collected death cap mushrooms in that process, before dehydrating them, placing them into a Tupperware container with other dehydrated mushrooms, and therefore unknowingly including them in the beef Wellingtons. But Dr. Rogers said the only evidence of Erin ever foraging for mushrooms came from her. Her children told an investigator that they did not know their mum to pick and eat wild mushrooms, and Erin never discussed foraging with her Facebook friends. Dr. Rogers explained to the jury why the prosecution say Erin lied about foraging.
The suggestion now that these mushrooms may have been accidentally foraged, we suggest, is a very late change to the accused's story. You might think that at some point it dawned on her that the Asian grocery story didn't add up, particularly when faced with the evidence about the remnants of the death cap mushrooms having been found in her dehydrator. She had to come up with something new. You should simply disregard this new claim that this was a horrible foraging accident as nothing more than an attempt by the accused to get her story to fit the evidence that the police compiled in this case.
Dr. Rogers then moved on to motive. She said the evidence didn't demonstrate that Erin had any particular motive.
Motive is not an element of the crime of murder or the crime of attempted murder. And it is only the elements of the offence that you must find proven beyond reasonable doubt. That makes sense. People do different things for different reasons. Sometimes the reason is obvious enough to others. At other times, the internal motivations are only known by the person themselves. You don't have to know why a person does something in order to know they did it.
While Dr. Rogers said the prosecution didn't need to prove motive, she still took the jury to evidence about the relationship between Erin, Simon, and Don and Gail. She told the jurors they had heard evidence over the course of the trial that showed that they loved each other. Dr. Rogers added that Erin professed her love for Don and Gail in her record of interview, and Simon testified that Erin seemed to love his parents. But she said the relationship between Erin and her parents-in-law was not always a harmonious one after a child support dispute arose between Erin and Simon in October 2022.
Don and Gail were dragged unwillingly into the conflict between the accused and Simon over child support. That was Simon's evidence. Simon said he noticed a substantial change in his relationship with the accused in late 2022 over the issue of child support, which had not abated by the end of that year. As you have heard, child support became a significant source of tension between the accused and Simon Patterson. How much Simon Patterson was paying, whether it covered the school fees, and the payment of the children's medical bills.
Dr. Rogers said that the evidence showed that the divide between Erin and Don and Gail was deeper than they ever knew. She said that Erin expressed her true feelings to her Facebook friends in bitter, angry messages she wrote about her parents-in-law, where she called them a lost cause and said, "F*** 'em."
The point of this evidence is that it shows, we say, that the accused was leading a duplicitous life when it came to the Pattersons. She presented one side while expressing contrary beliefs to others.
Then Dr. Rogers asked the 14 jurors to personally think about what they would do if this was a horrible accident that happened to them. Laura, as Dr. Rogers explains, our listeners may also think about what they would do if they were in this situation.
If you were told that the meal you had cooked and served to your family was thought to have possibly contained death cap mushrooms, what would you do? Would you go into self-preservation mode, just worrying about protecting yourself from blame? Would you race away from the hospital and do who knows what for an hour and a half? Would you be reluctant to receive treatment? Would you take 2.5 hours to eventually agree to get your kids to hospital? Would you lie about the source of the ingredients to medical practitioners and the health department officials for days, even though the truth might help those you claim to love? No, that's not what you'd do. You would do everything you could to help the people you love.
She went on to say,
you would tell the treating medical practitioners every skerrick of information that might help to identify the cause of the illness so that they could get the right treatment to your loved ones, regardless of any risk of blame that might fall on you. If your children had come within cooey of the same meal, you would move mountains to get them to hospital as quickly as possible. And if you, yourself, had truly consumed the same meal, you would gladly receive all of the medical treatment you could get your hands on. Erin Patterson acted the way she did because she knew what she had done.
Dr. Rogers said that Erin panicked not because she realised she had made a grave foraging mistake, but because doctors had figured out that death caps were behind the illnesses of the guests. She said innocent panic did not explain the extensive and prolonged efforts that Erin went to in order to cover up what she had done. She said it also did not explain why Erin chose to persist with her lies when the lives of the guests were at stake.
Dr. Rogers first took the jury through the lies Erin has admitted. Lies about never owning a dehydrator and never having foraged for mushrooms.
But then Dr. Rogers turned to the lies Erin hasn't admitted. She said these included lying in her record of interview about being very helpful to the Department of Health, lying about why she held the lunch, and lying when she said she never told the lunch guests that she had been diagnosed with cancer. But Dr. Rogers said her starkest lie was the one she told about having an appointment to explore gastric bypass surgery.
The prosecution says that you cannot accept the accused as a truthful, honest, and trustworthy witness. She has told too many lies, and you should reject her evidence.
Dr. Rogers told the jury to think of the case like a jigsaw puzzle. One piece on its own may not tell you very much about what the picture is, but when you start putting more together and looking at it as a whole, the picture becomes clearer.
Dr. Rogers then revealed to the jury that there was one final deception, a fifth, that she had not previously mentioned.
The deception she has tried to play on you, the jury, with her untruthful evidence. When she knew her lies had been uncovered, she came up with a carefully constructed narrative to fit with the evidence. Almost. There are some inconsistencies that she just cannot account for. So she ignores them, says she can't remember those conversations, or says other people are just wrong, even her own children.
As she neared the end of her closing address, Dr. Rogers said that the evidence in this case showed that Erin prepared and allocated the meal, that she was the only person who consumed the meal but did not fall seriously ill, that she was familiar with the iNaturalist website, that her phone was in the very two locations in Gippsland where death caps had been sighted and recorded in April and May 2023, that she was dehydrating mushrooms consistent with death caps and remnants of death caps were found in her dehydrator, that she concealed her actions, including by dumping her dehydrator, and finally, that she told many, many lies about the true source of the mushrooms. Dr. Rogers told the jury when they consider all of this evidence, they will be satisfied that the accused deliberately sourced death caps, served them to Don, Gail, Ian and Heather, and did so intending to kill them. She then thanked the jury before returning to her seat.
Erin's barrister, Colin Mandy, then began his closing address.
He started by telling the jurors there were two simple issues that they had to determine. The first was, is there a reasonable possibility that death caps were put into this meal accidentally? And the second was, is it a reasonable possibility that Erin did not intend to kill or cause serious injury to her guests? He said if either of those were reasonable possibilities, then the jury would have reasonable doubt and must acquit his client of all charges. He then made a criticism of the approach taken by the prosecution in this trial.
Their approach is this: working from the assumption that Erin Patterson is guilty of these crimes, pick and choose the evidence that fits that theory, and then tie it all together in an attempt to present a coherent narrative and ignore the things that don't fit. So they have constructed that case theory by, as I say, picking and choosing evidence while ignoring the context, cherry-picking convenient fragments while discarding inconvenient truths.
Mr. Mandy then went on to tell the jury what happened in the wake of the lunch was a terrible tragedy. He said since the four guests were good, innocent people, the jurors may have a desire to punish whoever caused their deaths. But he told the jurors they must fiercely guard against that kind of reasoning.
Mr. Mandy then moved on to motive, or more specifically a lack of motive, and said that it made it more likely what happened was an accident. He told the jury that the defence had actually presented positive evidence of a lack of motive, dubbing it an anti-motive. It was at this point that Mr. Mandy pointed to Don tutoring Erin's son and the pair also completing science experiments together. He said that Erin had a motive to keep Don and Gail in her world. This is what he went on to say.
Absolutely no doubt that Erin was devoted to her children. Why would she take wonderful, active, loving grandparents away from her own children? At the time, the middle of 2023, she was in a good place. Erin was in a good place. She had a big, beautiful house. She had just landscaped the garden. She had her children, who she loves deeply. She had them with her most of the time, effectively sole custody. She was very comfortable financially. Her body image wasn't great. It hadn't been for a long time, but she was planning to do something about that. She was looking forward to returning to study. All things considered, she was in a good place, and in that context, we submit to you that she is most unlikely to have planned to murder people, especially if it is inevitable that it would be discovered.
Mr. Mandy then took the jury to the dehydrator. He said if Erin had been planning this murder from April 2023, she would not have bought the dehydrator in her own name with her own details, using her own credit card, taken photos of the dehydrator, taken photos of the mushrooms in the dehydrator, shared the photos in a Facebook chat, and waited so long before getting rid of the dehydrator itself. Mr. Mandy added that if she had planned to kill the guests, she would not have sent the images of the murder weapon and the murder method to her own Facebook friends.
Mr. Mandy told the jury that an intelligent person carefully planning a murder would know if you poisoned 4 people at a lunch at your house, the meal would be under suspicion and the focus would be on the cook very, very quickly. But he said, according to the prosecution theory, Erin pushed ahead with her lunch regardless. He admitted she panicked in the days after the lunch when, as the cook, the spotlight was on her. He said she dumped the dehydrator not to dispose of evidence, but because she panicked following a conversation she had with Simon, where he accused her of poisoning his parents with the dehydrator. He said her actions on the day she drove to the tip to dump it spoke volumes about her state of mind.
She drives to the tip in her own car, pays for disposal of the dehydrator with her own bank card, doesn't attempt to disguise those actions in any way. It could only have been panic, not because she was guilty, but because that's what people might think. It was a deep shock to her how these 4 people became so seriously unwell. It was a deep shock to her because she never intended it to happen. And if that's a reasonable possibility, then she must be found not guilty.
Mr. Mandy then moved on to the leftovers of the meal. He refuted the prosecution's claim that Erin had been forced to tell police where the leftovers were.
She told the police where to find them without hesitation. She must have been confident that there was no poison in order to do that.
He went on to say,
a guilty person on the Crown case, being at the premises for some time that morning, would have already thrown them out. You might think, get rid of them, put them in the neighbour's bin or a public bin, bury them in the backyard or do something else. There had been 2 days to do all of that, instead directing the police where to find the evidence that there were death cap mushrooms in the meal. At that time on Monday morning, the inference that you can draw from that is that she genuinely believed that there were not death cap mushrooms inside that bin, inside those leftovers.
Mr. Mandy then spoke about Erin taking to the witness box. He said she didn't have to do this. He reminded the jury that she was cross-examined for 5 hours a day, over 5 days, recounting information from 2 years ago, and was questioned about every minutiae of her movements and every single conversation she had with the witnesses in this case.
She has the right to silence. She didn't have to answer any questions. She could have stayed in the dock and said absolutely nothing, not given evidence in the case. The prosecution has to prove the case, and that's part of the exercise. She doesn't have to prove anything, and yet she decided to give evidence, to give her account, and to subject herself to several days of cross-examination by a very experienced barrister. Let's consider her position in choosing to do that. Not only your scrutiny, of course, but the scrutiny of the whole world, being closely cross-examined about the fine details of her account and about every word that she said to other people 2 years ago in 24 hours to 48 hours.
Mr. Mandy's closing address finished early today because he was starting to cough and his voice was failing him, but he will continue tomorrow.
And before we jump off the mics, I will add that Justice Christopher Beale gave the jurors and us an update on the trial timeline. He said he won't commence his charge or his instructions to the jury until Monday next week, flagging that he might finish on Tuesday afternoon, or maybe he'll spill over into Wednesday. He said he wanted to provide them with this update so they could get their affairs in order before deliberations begin.
So, Laura, it looks like the jury won't retire to consider a verdict until mid-next week.
So we have a few more days left to go.
We sure do. To stay updated on this case, go to themushroomcook.com.au.